Welcome to the panel this morning on the Directive on Protecting Personal Data processed for the purpose of criminal enforcement, law enforcement, and police cooperation. We have distinguished speakers. Unfortunately, one sign is missing, but this is Vagelis from the Brussels Privacy Hub, so we welcome him as well. Maybe you get a name tag a bit later. Sorry for that. I will briefly... Yeah, and my name is Franziska. I will briefly present the speakers. I'm just the chair, so responsible for timekeeping and for the presentation of the speakers. We have Juraj Sajfert from the Commission, who actually was one of the negotiators of the directive, and he works in DG Justice. He will speak about the scope, the obligation of data controllers, a bit whether there will be more transparency for citizens, and a bit about the transfers. He will speak first, then we have Töpfer from the German Institute for Human Rights, working on human rights in policing and counterterrorism. This is an organization, the German Institute for Human Rights, founded by the German Parliament, and he will discuss problems arising from the exemption of data processing for the purpose of national security, and in particular in relation to fusion centers and to a pan-European fusion center that was established last summer at the headquarters at the Dutch Intelligence Agency. Then we have Jaroslaw Lotarski from DG Home, who is in charge of data protection in police and justice. He works in the Police Cooperation and Information Exchange Unit at the Commission. Previously, he was at the EDPS, and he will also go a bit more into the details of the national security exemption and Article 9 of the directive. And then Vagelis. You have a chair now, at least. Papakonstantinou from Brussels Privacy Hub. He will speak in his private capacity as a researcher, as I understood. And he will present some new proposals on the directive and talk about the enforcement issue. And least but not last, Katarzyna Szymielewicz she's the president of the Panoptykon Foundation, the Polish NGO defending human rights, and most of you will know her. She's also the vice president of European Digital Rights. She will be the moderator today, and I will hand over to her now. And yeah.
Good morning. Thank you, Franziska. I'm happy to moderate this panel. I hope to limit my interventions to the minimum so we can have more space for a real discussion. Also, we asked our panelists to keep their interventions short and dynamic so that we can really jump into interaction in less than 40 minutes, I hope. And as Franziska said, we will start with Juraj explaining to us his point of view on what are the main victories or main achievements of the directive in terms of especially protecting individuals from surveillance and from potentially abusive collection of data which might happen in the context of law enforcement. We would also like you to expand a little bit in your first intervention on the concept of national security. Why is it at all mentioned in the directive if we all seem to agree on the fact that EU has no competence to regulate this area? So why do we still have exemptions or mentioning of national security in the text of this document? Juraj.
Well, good morning, everyone, and I understand I have 10 minutes for the intervention, right? This is not very fortunate for me because this is actually my favorite topic, and I was so excited in data protection, not in life. But I was so excited that I could barely sleep, and I'm really happy that we have this panel. It's not very often that we have discussions on this legal instrument, and I'm extremely grateful to the organizer and to Franziska and Katarzyna for setting this up. Why I'm excited about the directive? Because I think it's really a major improvement compared to the data protection instruments that we had previously in the European Union. In particular, I'm here thinking about the framework decision from 2008, which covered only cross-border data. And this brings me to my first point, which is the scope of this directive, and why I think this is a major improvement, because the scope of this directive is much broader than the framework decision. It covers all sorts of processing by the authorities that are competent for law enforcement. So it doesn't make any more a distinction between cross-border data being governed by those few rules that are laid down in the framework decision and national data, or let's call it domestic processing, that was covered by national law. So that is already a major improvement, because not only the rules are much more extensive in the directive than what they were in the framework decision, but also the scope is broader. But when we come to this, when we speak about the scope of the directive, we also have to distinguish between where the GDPR comes and what is then left for this directive. And I have to say that in order for this directive to be applicable, you have to satisfy both the personal scope and the material scope of the directive. They have to come together in order for this directive to be applicable. So it means that if you are an authority competent for law enforcement, like police or prosecutor or judge or prison, then you can satisfy the condition of the personal scope. But you still need to satisfy the condition of the material scope, meaning that you have to be processing personal data for the purposes of law enforcement. So if you are a police authority who is processing data for other purposes, like the most obvious example, HR data of your employees, but also some other things which are not part of the former third pillar, like border control, then you have to actually apply GDPR, not the directive. So we have to always have in mind that the scope needs to be limited to its area and not allow overly broad interpretation of the scope. But here I come to another point, which is, and this is something that I hear very often in, even I read it in some academic articles and publications and so on, which is the applicability of the directive to criminal proceedings before criminal courts. And I don't understand why. I would really like to have a discussion afterwards on this. There is an impression that the directive does not apply to criminal proceedings. I don't see it anywhere, and I don't understand why there is this impression. Because I think the directive obviously applies to criminal proceedings. It's just that when member states are transposing it, the directive, they won't have to legislate a lot on the rights of data subjects, because those rights would already be normally covered in the criminal procedural law. So there is not much more to transpose compared to what you already have in your criminal procedural law, but it doesn't mean that the directive doesn't apply. So that's one important part of the scope. And then we come to the question you raised, Katarzyna, about national security. And you rightfully said, of course, we cannot legislate on national security. To answer your question, why do we even mention that in the directive? Well, apart from mentioning that it's excluded from the scope, we also mention it as one of the grounds for restricting data subject rights. But we have to make a clear distinction between what is the purposes of the processing and what is the ground for restriction of data subject rights. Meaning that I could be, for example, I could be a police authority who is processing data of someone for the purposes of criminal investigation. So let's say that this person is a suspect. And then this person might exercise his, or try to exercise his right of access to personal data. Whether I will be able to restrict his right or not as a competent police authority depends on whether there are any grounds for restriction of his right. And these grounds have to be laid down in law. This is a requirement of the directive. There has to be a legislative measure laying down the restriction, which has to be necessary and proportionate in a democratic society and respect the essence of the right, meaning that it has to satisfy the criteria that is laid down in the Strasbourg court case law, and also it has to satisfy the quality of law criteria, meaning that it has to be foreseeable, accessible, and so on. So this is already a major improvement for data subject, because the directive does not allow ad hoc restrictions. It does not allow police to say, in this case we need to restrict data subject rights of access because we think that they should be restricted in this case. No, it needs to be a legislative measure that needs to be necessary and proportionate towards the data subject and his right. The grounds for restriction can be the purposes of national security. So the national law can tell me that in such and such cases, for reasons of national security, you shouldn't allow data subject to exercise his right of access. You should restrict it. But it's not the purposes of the processing. I am doing my normal criminal investigation. I'm not doing processing for national security purposes. And this actually, when I speak about exercise of data subject rights, this leads me to the second point of my intervention, which is the new obligations of data controllers that are in this directive. And they are actually the major improvement, and they are a major additional safeguard compared to today's situation when it comes to data subject and their rights. There are a number of new things in the directive. One of them is the principle of direct exercise of data subject rights. Because now, if you look at the current union legislation and some national laws, they actually allow to member states to have a choice whether data subjects will exercise their rights directly against the data controller, such as police, prosecutor, courts, prisons, or they will not be able even to address the data controller. They will have to go to the data protection authority. So that's what we call the indirect access or indirect exercise of data subject rights. And this was allowed until the directive. Now, as a rule, you have to have direct exercise against the data controller. And only if you come to a situation where your right has been restricted, for example, on reasons of national security, but also for other reasons like jeopardizing the investigation, only then you will go to the data protection authority. And that is something that is another safeguard built in the directive, because sometimes you will not even get information on why your right has been restricted, because even telling you why your right has been restricted would jeopardize the investigation. So if you receive a reply from the police saying we can neither confirm nor deny we are processing your personal data, you have a safeguard, because then you go to the data protection authority, and the data protection authority will exercise your right on your behalf and will tell you that they have checked everything and they have done the necessary verifications. And there are a number of other guarantees or other new obligations of data controllers, such as data protection impact assessment, accountability, prior consultation, data protection by design, data protection by default, notifications of personal data breaches, or mandatory appointment of the data protection officer. These are all new things that we can discuss. Logs, obligation to keep logs with justification, why someone has consulted a certain database, at what time, who was the one who consulted it, why someone has conducted, a police officer has done a disclosure of personal data or a transfer, and so on. And finally, when it comes to Article 39 of the Police Directive, which is about the asymmetrical transfers. I think Juraj will speak more about this, but I just want to say that as a rule, international transfers have to take place from law enforcement authorities to other law enforcement authorities. And there is an exception, which is for individual and specific cases, and these are the asymmetrical transfers in the in Article 39, and they are allowed basically in order for law enforcement authorities to be able to send some data to service providers in third countries like IP address in order to get some data in return because of the cybercrime issues, like subscriber information, for example. But I think this is the way we framed now our request towards third country authorities, and that's how we can also expect third country authorities to actually frame their access rights to European Union service providers. Thank you.
Thank you, Juraj. So from what you said, I actually understand that EU in a way decided that the same data protection principles should apply to all activity of member states, including national security, but it was in fact exempted with this broad clause saying that in that context individuals cannot exercise their rights, and also other aspects of rights and obligations of data controllers are limited. So I still keep my point that I don't quite understand this construction, but maybe we will dive deeper into this in the discussion. At that point, I would like Jaroslaw to explain us more about the asymmetric transfers, and also share perspective of somebody coming from DG Home and from the perspective of somebody who knows law enforcement from the inside. To what extent, in your opinion, Jaroslaw, this instrument will actually affect the practice of law enforcement agencies? Is it going to complicate at all their work or increase, for example, access to information in a meaningful way of individuals to data collected about them? Do we have that chance, or it will all depend as it was so far with the practices of member states?
Good morning. Thank you, Katarzyna. I will spend my 10 minutes mainly on the issue of national security and asymmetric transfers, how Juraj called them. So transfers not to law enforcement, but to other parties, mainly private parties, internet service providers. National security, and that is potentially an important point. And I start with a provocative example. A month ago, in 21st of December, the court delivered a very important judgment on data retention. And the court basically said that generalized indiscriminate data retention of communication data is contrary to EU law. We are in the situation where large majority of member states do have such measures in national law. And now, a few weeks after the judgment was delivered, some member states are trying to find a way to save their laws. And we hear ideas like, well, as national security is outside the scope of EU law, let's say that data retention is not for law enforcement, but for national security, and then everything is fine. And this court in Luxembourg, they cannot, judge me this because it's outside the scope. So there is a potential for use or abuse of that exception. So where we actually stand with this national security, where this comes from. In the directive, when you look at Article 2, the scope of the directive, there is a provision saying that this directive does not apply to the processing of personal data in the course of an activity which falls outside the scope of union law. The text of the directive, the Article 2 does not specify what this is outside, what is outside the scope of union law, but if you look at recitals, recital 14 explicitly refers to national security. So the recital 14 says that since this directive should not apply to the processing of personal data in the course of an activity which falls outside the scope of union law, activities concerning national security, activities of agency or units dealing with national security issues, should not be considered to be activities failing within the scope of this directive. So we have an explanation that national security and activities of, let's say, intelligence agencies do not fall within the scope of the directive. And the directive would somehow imply, by this recital 14, that national security and intelligence agencies' activities fall outside the scope of EU law. Is it true? I'm not saying it's not true that it falls outside the scope of the EU law, but it's maybe not that clear. So what the EU law basically says, if you look at the treaty, we have the famous Article 4, paragraph 2 of the Treaty on the European Union, saying that the Union shall respect the equality of member states and other number of things like national identities, etc. And there is a last part of the last sentence of this paragraph saying that in particular national security remains the sole responsibility of each member state. Sole responsibility. It doesn't say it's outside the scope. It says that it's a sole responsibility of each member state. Does it mean automatically that it's outside the scope of EU law, that EU law cannot legislate on it? Probably it is difficult to legislate on national security. But at the same time, if you look at the EU treaty and the treaty on the functioning of the EU, what will you find? You will find a section which is called, I don't want to make a mistake, Provisions on the Common Security and Defense Policy. So probably the Common Security and Defense Policy, the former second pillar of the EU, this is something related to national security. So how come this is a sole responsibility of member states, but at the same time you find something on defense and common security in the treaty? Then you may find something probably more lightly related to national security, like terrorism. Article 75, for instance, refers to terrorism. Is terrorism related to national security or to prevention, investigation, detection, or prosecution of crime? Is it a crime? Probably it is, but very serious. So from which point the terrorism is national security issue and stops to be really a criminal issue? You need a big bomb or kill many people. If you kill little number of people, that is still crime. And then if you kill a lot, that is national security. Where it starts, where it stops, that is not very clear. We also have other provisions in the treaty, Article 72, 73 in particular, referring indirectly to this sort of issue. So Article 72, for instance, said that this title, it's a title about area of freedom, security and justice. This title should not affect the exercise of the responsibility incumbent upon member states with regard to the maintenance of law and order and the safeguarding of internal security. Here it's not national but internal security, so not external but internal security. Article 73 refers to the possibility for member states to organize between themselves, so no legislation here, forms of cooperation between their intelligence agencies. So the treaty says competent departments of their administrations responsible for safeguarding national security. So what we can make out of it? First, we have an issue of scope. What is the scope of this national security? Oh, sorry, 2 minutes. The scope of national security is unknown. That means that there is no definition in the treaty, in secondary legislation, in the court case law of limits or boundaries of the national security exception. The court produced a judgment in Sakurdi's case where a definition, quite comprehensive definition of public security was provided in 2010, but it's probably something different than national security. So we do not know if, for instance, data retention is national security or it's law enforcement. What is exact purpose of national security and purpose of preventing serious crime? Where is the boundary between them? This is not defined as far as we can say it today. The second question, which is important in this context, is what is the legal consequence of that exception from the scope, let's say, of the EU law for national security? What does it concretely imply legally? Does it imply that EU has no competence in areas of national security? Yes, probably we have no legal base to legislate on national security. But there are, as I said, provisions in the treaty which of course relate to national security. Another question is the processing by national security authorities, I mean intelligence agencies, special services, covered by EU law or totally outside the scope of EU law? I think the answer we normally say is that it's of course outside the EU law, but we have some interesting precedents, and the one I will quote is the Eurodac regulations, Regulation 603/2013, which provides in Article 5 that member state cannot designate intelligence relating authorities, intelligence relating to national security, authorities exclusively responsible for intelligence relating to national security, as recipients of data from Eurodac database. So EU law is explicitly prohibiting intelligence authorities, agencies, to access EU database. So there is a possibility for legislation. This was adopted. Okay. I try. The last question, and I stop there with this national security and with my presentation, is whether it's to know whether Article 4, Paragraph 2 of the treaty, so this provision stating that national security is the sole responsibility of member states, is this provision is this provision allowing the member states to somehow justify their national measures and bring them outside the scope of EU law? And here we have a case related to free movement of people. It's a ZZ case from 2013. It was related to somebody who could not enter United Kingdom for national security reasons. And the court said explicitly in this case that, that's the last thing, and I finish with this. It is clear that reliance by a member state on interests of state security does not rule out the application of EU law, and in particular fundamental rights protected by the Charter. So in data protection context, could we say that, if I go back to this data retention example, if a member state has a data retention law and claims that this is for national security and not law enforcement purposes, it is quite unlikely that that sort of argumentation could stand. Thank you, and sorry for...
Thank you for trying to explain us this topic, which is, as I think everybody can see at that point, not a very easy thing to grasp and even less to explain in 10 minutes. But to make it even more complicated, I would like to bring the fact that the cooperation between police and secret intelligence is a fact. And also the borderline between those two types of agencies very often gets blurred. And here comes Eric Töpfer with his expertise on practices of those entities. In particular, Eric, you have researched what happens in the fusion centers, at least in Germany, but maybe also beyond. So please share with us your observations and your idea about how that directive could, if at all, change the status or the practices happening on the borderline between secret services and law enforcement.
Yeah, thanks, Kasia. Good morning. In a sense, I'm somehow trying to illustrate the problems that Jaroslaw talked about by providing an example, which is, I think, really a matter of concern at the moment. So I will talk about fusion centers in general, but in particular about one fusion center which was established last year. And my question is, it's the very same question that Jaroslaw raised, is if the directive could apply to such forms of cooperation. So my particular concern is a fusion center that was established last summer under the roof of the Dutch intelligence agency AEVD, which has its headquarters near The Hague. So the context of this fusion center was the so-called counterterrorism group. This is an informal network of intelligence and security agencies of 30 European nations, namely the 28 EU member states, Norway and Switzerland. The counterterrorism group was established after 9/11 outside the structures of the EU, and it is an informal network still. There are only few information available about this new fusion center, which I draw from press releases by the AEVD, so the Dutch intelligence services, and answers of the German government to information requests by the opposition in parliament. So what we know from these information is, so the platform has two components. First, it's a platform where liaison officers meet from intelligence or security agencies on a regular basis. So they travel to meetings, to this headquarter near The Hague to exchange information and threat assessments, etc. And secondly, it is an international data, so it contains an international database which is fed by data or with data from these agencies which cooperate there. According to information by the German government, no written agreement or memorandum of understanding exists on the establishment of the platform. It is solely based on a decision of the heads of the agencies. The data shared via the databases are reported to focus on Islamist terrorism and so-called foreign terrorist fighters, and is allegedly not intended to expand the scope to other phenomena. Apart from the information that no biometric data are shared, it remains unclear which other types and categories of data are processed. So, in a sense, it's a black hole. We don't know much about this. The German government is refusing to provide information about the participating agencies to the national parliament because, as the government claims, this would violate the so-called third-party rule, according to which no information that was received from foreign partner agencies may be shared with third parties without consent of the agencies who have transferred the information. So we have a fusion center which is set up and nobody really knows, except from the agencies and persons involved, who participates. But at least the German government reports that in August last year, 23 agencies from the 30 countries of the counterterrorism group network were participating at this platform. However, if we look at the likely candidates for participation, so the Fundamental Rights Agency of the EU had published last year or the year before a comparative report on the oversight of intelligence or of surveillance by intelligence agencies, which has a list of the intelligence agencies across the EU, domestic agencies, foreign agencies, and the agencies in the field of military intelligence. And if you look at these lists, and in particular the domestic intelligence agencies who are likely to be present at this platform, we see that many of these agencies are not simply intelligence agencies, but security agencies that are part of the police. For instance, the Polish internal security agency, ABW, the Austrian Office for the Protection of the Constitution and Combating Terrorism, BVT, the Swedish SÄPO or the Estonian KAPO. Meanwhile, the European Commission is encouraging the member states, and I quote, to consider opening the counterterrorism group to interaction with law enforcement authorities cooperating within the framework of Europol, within the context of the European Counterterrorism Center, with the objective of linking the dots. Some form of information exchange hub could offer a platform where authorities obtaining information relating to terrorism or other serious cross-border crimes would share it with such law enforcement authorities. And meanwhile, Europol has established links with the counterterrorism group. So there are meetings, and there are also meetings between Europol officials and representatives from the national security agencies. At least from the German perspective, this is a very dangerous trend, because under German constitutional law, the intelligence agency can transfer data to the police only in the name of outstanding public interest. So, as a rule, or as a general rule, intelligence agencies must not share their data or their information with the police, only in only in the name of outstanding public interests. So, this platform has no external oversight by German data protection authorities, and the oversight by the intelligence control panel of the parliament is limited by the third-party rule, and in addition, as the collaboration takes outside German territory, the inspection rights that the control panel has cannot be exercised. So in a sense, it's, at least from the German perspective, it's a black hole in the rule of law. As I heard, the Dutch oversight body, they have started to do an investigation and will or are collaborating in this investigation with other oversight committees. And they have said that their report will be published in March, so I'm very keen to see the report. But at the very moment, we have no idea what happens there and what is the legal assessment of the things that are ongoing there. So my question for the debate is the same question that was raised already. Could we apply the directive for this form of cooperation to make it more accountable? So recital 14 of the directive was already quoted, and it seems to be quite clear. So national security falls outside the scope. However, if we look at Article 3, Section 7, which defines the competent authorities as any other body or entity entrusted by member states law to exercise public authority and public powers for the purposes of the prevention, investigation, detection, or prosecution of criminal offenses or the execution of criminal penalties, including the safeguarding against and the prevention of threats to public security. So if we look at that security agencies are present with clear police function at this platform, I think there is an argument that these would also fall under the scope of the directive. And in addition, I think we observe that the focus of the work of intelligence agencies, so the nature of intelligence work has changed significantly in the recent 2 decades. Meanwhile, many of these agencies are seen and consider themselves as part of the security community whose aim is to combat terrorism and partly also organized crime. So even the German Federal Office for the Protection of the Constitution, so our domestic intelligence agency, meanwhile claims to be an authority in charge of the prevention of threats to public security, as I learned at an event in Berlin last November. Thank you.
Thank you so much for this excellent case study showing the complexity of how that law could apply, or how it's actually not able to apply in a very important context of law enforcement cooperation. You mentioned, Eric, Europol, which is sort of EU institution, and that brings us to the question how, again, the directive and other instruments will affect the behavior, the operations of law enforcement institutions within the EU own structure in a way, and here comes back the topic of the regulation 45 2001, which now will be replaced with a new instrument. So we have here Vagelis, who promised to give a short, very short overview of that new instrument, but focusing again on how that new instrument might affect again the complicated landscape of law enforcement cooperation involving EU-owned institutions. Please, Vagelis.
Thank you, Katarzyna. First of all, I would like to please allow me to say that I'm very happy with the panel composition. I have to congratulate the moderator and the conference organizers, because so far it has given us a unique opportunity to witness the one side of the conflict, of the undergoing conflict that lies beneath the directive and the law enforcement field in the EU. And we have 3 distinguished members of the Commission, all of them, if you allow me, adopting an expansive view of whether the directive applies. So Juraj told us about criminal proceedings and towards a positive manner. Jaroslaw discussed about national security and tried to find wording that can accommodate the application of the directive, and Eric did the same. But at the same time, Eric demonstrated through a concrete example that member states see things differently. And indeed, if the panel had another composition and member states were represented here, or even authorities from Europol and Eurojust, maybe the approach would be different. And being on the other side of negotiations in the past, that of member states, but not speaking in this capacity, I would like only to highlight that on the one hand, when one enters into negotiations at council level mostly, with regard to these instruments, the directive, 10 years ago the framework decision, and now we'll see how the regulation, the new regulation 45/2001 goes. There is an underlying conflict of member states wishing to safeguard their independence when it comes to law enforcement and national security, of course, so the interplay there is right. And on the other hand, the Commission that by definition wishes to see EU instruments applicable in those fields as well. So with regard to the new regulation, I'm going to discuss a bit briefly about what happens at EU level when it comes to law enforcement. And the situation is a bit vague for the moment. One has to do combined reading in order to formulate the complete picture. But what is the state of the art right now is that law enforcement agencies at EU level, most of them, the vast majority of them, with the exception of Europol and Eurojust, are regulated by Regulation 45 of 2001. And the EDPS is carrying out supervisory authority over them. This presents a difficulty at first level because that regulation was not released to cover this area. But then over the years, most of the agencies practically voluntarily submitted themselves to that regulation and to the authority of the EDPS. But what is actually happening with each one of the agencies is that each one in its own constituting text has a few paragraphs on data protection. So what applies for each different agency is its own data protection regime, and on top, Regulation 45/2001, which was not again designed to cover these areas, but still. And this happens at EU level. When it comes to member state level, then member state laws evidently apply. So the same database, when it resides in a member state, we have member state law that will be harmonized through the directive that we are now discussing. But while at EU level, then we have the custom-made per agency or per body. And when I'm talking about these agencies, I'm talking about OLAF, VIS, SIS, Eurodac, Frontex. And these agencies have their own regime, and then Regulation 45/2001. In practice, a coordinated supervision model is applied by the EDPS and the joint council that regulates data protection matters within the agencies. And maybe it works seamlessly, maybe it does not. There is not much reporting on what has been going on, and there is not much information. At any event, the directive, as its predecessor, the framework decision, excluded itself from regulating this, excludes itself from regulating EU agencies. A directive, of course, could not regulate EU agencies in any case. But it again shows the tension now at EU level. First, member states want to safeguard their own jurisdictions against EU intervention. And now EU agencies want to safeguard their own legal regimes against harmonized intervention. So the framework decision back in 2008 excluded itself from regulating EU agencies, and the directive now in Article 62 also excludes itself from regulating EU agencies. In pursuit of the directive, or after the directive, we had Europol and Eurojust regulations, draft regulations, which indeed brought Europol, and will be bringing Europol and Eurojust under the Regulation 45/2001 and the EDPS supervision model. So, at least in the immediate future, all EU law enforcement agencies will be brought under the under the Regulation 45/2001. I know it is complex, but it kind of works that way. And, but of course, it being outdated, only 10 days ago, we have a new proposal for a draft regulation, 45/2001. And I'm not going to go into any detail on that because it's a big and ambitious text. And it makes more reference to the general data protection regulations saying that it is aligned to it and drawing parallels, explicit parallels between the two instruments. As far as the directive is concerned, it says precious little about its relationship with it. Only passing reference is made in its text. Again, it says in its preamble, the new draft regulation, that the rules of union agencies should draw on the principles underpinning this regulation and be consistent with the directive. So again, this regulation does not affect the custom-made data protection rules per agency, but it only says that you can keep them, each agency can keep its own regime, but your principles must be consistent, should draw on the principles, on my principles, me being Regulation 45/2001, and be consistent with the directive. So we remain under the same model of per agency data protection rules under a coordinated supervision approach. The only thing remaining is that the Commission has the opportunity to review whether this is indeed the case and make a proposal to amend. But this will happen in the future. So this is all. I tried to, it is a complicated matter because each agency has its own rules ultimately, and it has to be judged on an individual case. But I tried to bring the picture as close to the reality as possible. Thank you.
Thank you. We will open now the floor to questions and comments, but maybe as you are thinking about your questions and comments, I would briefly just like to check with the panel if there are any follow-up quick comments to what we heard. Maybe something was not correct according to some of you, or you would like to clarify, then please jump in now.
Yeah, I'll be very brief on for me, the problem with the distinction between the directive as for law enforcement instrument and national security is not that big, because again, for the reasons that you have to meet both the personal and material scope in order to apply the directive. So if you are a law enforcement authority which is competent for law enforcement and you do processing for law enforcement purposes, only then the directive applies. So if you are not a law enforcement authority, the directive cannot apply to you in any case. So I think the problem can appear in case national security agencies start acting as law enforcement agencies, then and start doing processing for law enforcement purposes, for investigation of criminal offenses, not for national security reasons. And the national security, as I said, the grounds for restricting data subject rights, that's a completely different story. National security, you can restrict grounds, you can restrict data subject rights on grounds of national security also in the GDPR, in Article 23. On the second intervention on 45/2001, I was one of the authors of the new proposal, and just wanted to say that we don't affect the standalone data protection regimes for the law enforcement agencies, such as Europol and Eurojust, with the new proposal. They remain in place, and there are no other law enforcement agencies which act as data controllers in the union institutions. There will be maybe EPPO, which will have its own standalone regime. Again, OLAF is an administrative body, part of the Commission. It's not a law enforcement agency. SIS, WIS, Eurodac, there is no EU data controller there. So we have to distinguish between substantive rules and supervision. If you have coordinated supervision by EDPS and national data protection authorities, that is one issue, and substantive rules on data protection is another issue. And if we don't have a data controller at the union level, we don't have a problem with applicability of 45.
Thank you. That was very useful clarification. Do I see any voices coming up? Oh, I'm sure there are. Do you really want us to continue? Yes, please. Do we have a microphone? No?
It's in the middle.
Oh, it's in the middle. Sorry. Thank you for making the effort.
Good morning. Maris Rukas from Latvia NGO. My question is, or comment, maybe you agree or not. if this is a national security agency that maybe deals with some of criminal cases as law enforcement agency, is it correct that in some kind this directive applies, in some capacity not, and maybe even in some capacity new regulation applies, because this institution is also they have employees and so on. In capacity they don't work as a law enforcement but simply as a state institution. Is it correct, or what is the comment?
If the question is for me, the answer is yes. Yes, your interpretation is correct. I think this is exactly what you have to look at. Both the tasks of the authority in question and the purposes of the processing. So I totally agree with your interpretation.
We have a microphone standing in the middle, so please feel free to approach it whenever you have a comment or question. And now,
just a brief comment. I think I mean, it might, in legal terms, it might be quite clear. But if you look at the actual practice, for instance, the German domestic intelligence agencies, we had last year, the year before, there was the act was amended. So what they do now is that they collect as much information as they can to process this information and to deliver, as they say, tailored information to the police to guide their interventions. So is this a law enforcement function, or is it simply an intelligence function? I mean,
delegated intelligence
they are,
function
in a sense, they see themselves as a service provider for the police.
Please.
Hi, Edward Hasbrook, papersplease.org. Our experience in the United States leads to a lot of concern about the issue you've been raising of the national security exception and domestic policing by national security agencies. And part of the problem we've seen, for example, with the use of PNR data is that the supposed purpose of the processing of the data is national security and counterterrorism. But the use, when we ask, who are you actually stopping and arresting on the basis of PNR data, is almost all ordinary crime, mostly drugs. So you have a purpose of national security, but use for policing. Does that fall, if the purpose is national security, does that domestic policing use fall within the national security exemption in the European regulation?
It's a great question. Jaroslaw, will you take it?
Well, I mean, legally speaking, this falls under the directive. It's still prevention, investigation, detection, and prosecution of crime. But of course, as Eric said, one has to see how it will be implemented and transposed in national law, and then, of course, we have some doubts if it is implemented fully. What I would just add to what Juraj just said about this scope, of course the directive is clear. The directive says that only processing for purpose of prevention, detection, investigation and prevention of crime is covered, but it's not very clear what does it mean, mainly prevention. Prevention of crime, it's a very wide concept. I mean, investigation, it's more easy to define, but prevention, it can be any sort of information collection which is potentially prevention. So that does not, legally speaking, again, leave a lot of place for intelligence agencies to not be covered by the directive. But yeah, one has to see how it will be implemented.
Okay, so I might misuse my chairing capacity to ask a question to the Commission again about the new regulation 42/2001. Europe 45 2001. Sorry. So the Europol and Eurojust as well. They have a lot of third states agreement. Who will check that, and who will check the compliance with the new regulation regarding these third states agreement?
Well, I assume the question is for me again. So as I said, the new proposal for the revised or regulation that will replace Regulation 45/2001 does not affect standalone data protection regimes that have been adopted in certain instruments that are establishing certain agencies. One of them is Europol. It's quite new. It's going to be applicable as of May. And so the substantive data, again I come to my distinction, substantive data protection rules on processing operational personal data of Europol are solely laid down in Europol regulation, nowhere else. The supervision is also organized according to the Europol regulation, not according to the new proposal. And it takes place in a form of some cooperation board, which is which is composed of EDPS and national supervisory authorities. And there is a lot of detail in the regulation of Europol and who does what in that context. Eurojust still has the old regulation, which completely excludes both 45 and EDPS from the supervision, from substantive rules. So there is a joint supervisory body and all this, but I think Eurojust will follow the same model, because I've seen it in the European Public Prosecutor's Office, which follows a little bit different model, because the discussions are newer than Europol discussions, and you have this directive already in place. So in the EPPO you have a lot of rules of the directive as substantive data protection rules, and then you have the coordinated supervision model between EDPS and national authorities, which exists, by the way, in 10 other instances, so it's nothing new. And I think Eurojust will probably follow that model that we saw in the EPO discussions.
If I don't... Yeah.
I do not want to press you anymore, but because you seem to be making a very clear separation between substantive law and the supervision, to me it's not clear. Because, okay, if I was an auditor with the EDPS and I was entering Europol and I had Europol, not Europol, okay, a set data protection rules for Europol, and then I had this text saying that the rules should draw on the principles underpinning the new regulation and be consistent with the directive. And then I had a rule in front of me that to my mind was so and so. Who will do the legal exercise of aligning everything?
Well, look, this is exactly what the Europol regulation is saying as well. This underpinning principles and all these things. It's there in the Europol regulation as well. So Europol regulation has to be interpreted also in light of the principles that are laid down in 45/2001. But I haven't. The supervision needs to take place according to a certain set of rules, and these substantive rules are for Europol, and I assume it will be the case for Eurojust and EPO, will be laid down in a standalone regime in that piece of legislation. And I think it's clear from Europol regulation that it's the EDPS who supervises Europol, and it's the national authorities that supervise processing on the national level, because Europol is acting as a hub. So I think this model of coordinated supervision will be replicated in the future as well. And it just, so one thing is supervision, the other thing is which rules you should apply when you are doing the supervision. I think it will be probably more fortunate to have the directive rules applicable to all the agencies.
Absolutely.
Yeah. Because then you would have the same rules on the national level, and on the, now you have Europol has its own.
So why didn't you when you were drafting the new regulation?
Because these are the new rules that have just been adopted. You know, we cannot propose something to change of something that has just been adopted.
Too bad. We have a comment, please.
Hi, I'm Teresa Quinto from the University of Luxembourg. And,
Can you speak up?
Sorry. I have a question concerning, you said in terms of border control, the directive won't apply, which makes sense because authorities act in administrative functions. But if you look at the security discussions, you could still claim that it's for the prevention of crime, and then you could apply the directive, right? if you're a law enforcement authority, for example, if you look at the registering of irregular migrants, and you would claim we process the data for the prevention of crime, you could still apply the directive.
Is the question clear?
Yes. For me it is. Yeah.
Okay, so maybe.
So I'm monopolizing the panel.
No, Juraj, let's go. Yeah.
Okay, I'm sorry, but apparently the question is for me again. It's I think if you look at the architecture of the EU law, there was historically a distinction between where the rules on police cooperation and judicial cooperation in criminal matters were placed. They were placed in the third pillar, and this area is what the directive is about. And the borders have always been in the first pillar. So they were covered by Directive 95/46, and they should be covered by the GDPR in the future. Another issue is access, and that maybe is something for Jaroslaw to complement, is how law enforcement and under which conditions can have access to the data that are being processed for the purposes of border control and migration control. But then this will kick in. This is where the directive will kick in, when those data are starting being processed by the law enforcement authorities for the purposes of investigation of criminal offenses. But the normal activity of border control is definitely covered by the GDPR.
Thank you.
Jaroslaw has more expertise.
Well, I fully agree with you, right? So border control, it's not law enforcement. I mean, checking people on the border, not criminals because they cross the border or because they are asylum seekers or because they arrive by boat or something. So even if a criminal can be detected when crossing a border, this is not, purely speaking, law enforcement. So that is covered, of course, by GDPR, everything which is related to border control. As regarding access to EU databases by law enforcement, I mean VIS and Eurodac, and perhaps in the future, if that gets adopted, entry-exit system and ETIAS, the sort of system delivering travel authorizations to third country nationals from non-visa countries. So access to those databases is regulated by a specific legal instrument. So there is a specific instrument, there is a specific set of provisions in the legal basis for those systems, and each one is slightly different. And for the moment it's VIS and Eurodac. But then once those data are accessed by law enforcement, the directive will apply to the processing of this data. So access as such is regulated by specific provisions of each legal base of those systems, but then the use of this data would be regulated by the directive.
Thank you. If I don't see a comment or question, I would like to use the remaining minutes to ask my own very naive question, or actually ask it again, because that's with what I started. We have spent a lot of time discussing the scope, the applicability, the difference between substantive and procedural. The more we speak about it, the less I see what, in the substantive terms, will be the difference or the impact of the directive on the actual law enforcement practices. Namely, is, in your opinion, and that's mostly, I would like to hear Eric and Jaroslaw on this point, can you see a single standard that will actually appear, which wasn't there before, which will be binding on all member states and law enforcement agencies, regardless of all the exemptions? Or do we have a situation which I fear we might have, that we actually gained a complicated frame for the member states to assess the laws they create and apply, but really we are still very far from having even one concrete substantive standard that will go across all member states and all law enforcement agencies? So do you see a single thing that will really change across the board as a result of the directive on the substantive, in the substantive matter? I
have one example, which I hope at least it will harmonize the practice throughout Europe a bit more, is the processing of genetic data. So the collecting or the purposes for which DNA data or DNA samples can be collected. And I think the necessity clause, which is included in the provisions of the directive, might harmonize the practices across Europe a bit more than we have. And I think this has huge implications for the whole data exchange under the PRIM regime. But we'll see. I mean, we will see how the member states will implement this rule.
I mean, it's a very difficult question because one would need to compare all the 28, even more, because they are associated countries applying the directive, national systems, and see where there were some sort of loopholes or differences with the directive. But it's a directive, so it will be implemented. National laws on police or law enforcement will be modified accordingly. What I could quote as an example, but probably there are plenty others, it's the question of transfers by police to private parties outside EU. So we are speaking mainly about internet service providers in US or in that part of the world. So in some member states, those transfers were simply prohibited in national legislation, and anyhow, sometimes police or law enforcement did them, directly contacted Google or Microsoft or Facebook, whatever. Now those transfers will be lawful under the directive. So, yeah, but there is a significant impact in many member states, less significant in others, really depending on their national situation.
One of my main concerns, the reason actually I ask this question, is the fact that in Poland, the country where I mostly work when I'm based, we still don't have any legal procedure concerning access to data for individuals, enabling us to check whether we have been under surveillance or not, which is the standard in many other countries. And in my opinion, it's a very important safeguard coming from data protection regime, of course, with the exemption that it shouldn't be done as long as the case is running and as long as that could complicate criminal proceedings. And nevertheless, we need that kind of standard in Poland. I think we need it in many other member states. So that was one of the hopes we had, that as a result of the directive, we can actually gain a strong argument in our state to say we need that procedure to be established. So that was my hope, and it still is, in fact.
Yeah, if I can answer, yes, definitely. This is, as I already mentioned, this is one of the major changes of the directive and improvements. And as a rule, you have to have direct access, and only if it's limited, you have the restricted, you have the control through the DPA. So you also have to have the indirect access in case of limitations. So these are, and also I would like to underline the other stuff that are new, such as data protection by design, by default, and personal data breach notifications. That is going directly to communications to data subject about personal data breaches. Mandatory appointment of the data protection officer. So you have someone who takes care of compliance within the police organization, and you have, or other criminal justice authorities, and you have the new obligation to have very, very substantive logs on all your databases. So there are many improvements and cases where there is harmonization necessary and investment by national authorities.
Thank you. If we don't see any final comments, we will now come back to our chair for the summary.
Okay, I think if we don't have any questions, we will close that panel. I think what we saw is, or what we discussed in depth, is the national security exemption, which is, even if Juraj says it's clear for him, not necessarily clear if law enforcement and national security agencies mix. As Eric gave us this example with the fusion center, and it's hard for parliaments or national parliaments actually to have a clear view and transparent rules regarding these kind of mix centers between law enforcement and national security. We have some new improvements in the directive regarding data breach notifications, the obligations for controllers, and the direct exercise of rights for persons. I think this is something important to mention, that now we have it also in the police and justice context. Europol and Eurojust, I still see let's say, a small problem with their own regimes regarding the application of several, well, let's say, long-grown specifics in these agencies. We will see how this will interact with the directive in future, and maybe also through the supervision of the EDPS regarding, for instance, third states agreements. I think we can summarize that with we see some improvements and some, let's say, improved rights also for individuals in that context, but we still have some questions open, in particular regarding the mixture of national security and law enforcement. So I thank you for coming, and especially the panelists for being here, for making their points clear. Yeah, I think we can further discuss in the break. Thank you for coming.